present a bouquet to Additional Chief Secretary, sir. Now I would request Assistant Director Anita Baral ma'am to present a bouquet to Ms. Chaya Sharma ma'am. To officially start our event, it is my honor to invite Sri K. Mahesh sir, Special Director UTCS, to the stage to deliver the welcome remarks.
Good morning, ladies and gentlemen. Honorable Mr. Justice Ritu Raj Avasthi, Honorable Judicial Member of Lokpal of India and former Chairperson of Law Commission of India, Honorable Mr. Justice Manoj Kumar Ori, Judge, Delhi High Court, Professor G.S. Vajpayee, Vice Chancellor of National Law University, Delhi, Mr. Manish Gupta, Additional Chief Secretary and Director, UTCS, Ms. Chaya Sharma, Special Commissioner Police Training, Judge Trainees, Police Officers, Prosecutors, IS, Danics Probationers, and of course, I welcome our Honorable Chief Secretary, Sri Naresh Kumar sir, who has been instrumental in organizing this one-day training program. Ladies and gentlemen, in the words of the eminent jurist and former Supreme Court judge, V.R. Krishna Iyer, I quote, "Criminal justice is like a wheel, and if it is not keeping moving, it will rust. The wheel must be kept in motion through constant reform and adjustment," unquote. Ladies and gentlemen, it is in this spirit of constant reform that the Indian Parliament enacted the 3 new criminal laws which came into effect on 1st July 2014 and which have a massive impact on society at large. Coming to today's August gathering, it gives me a great pleasure to welcome each one of you on behalf of the Directorate of Training UTCS. The Directorate imparts training to the IS Agmut cadre, Danics Probationers, Das cadre, and other members of the autonomous institutions in Delhi. Ladies and gentlemen, since the implementation of the 3 new criminal laws, namely the BNS, the BSA, and BNSS, this Directorate has been active in organizing training programs on these new criminal laws. As part of the Vision 2047 document of UTCS, under the able guidance and supervision of the Honorable Chief Secretary, Mr. Naresh Kumar, a need was felt that the various stakeholders in the criminal justice system, namely the members of the judiciary, police, prosecutors, and civil servants, must sit under one roof and discuss and debate the issues concerning their functioning, as the departments function, act, and reflect in silos. Friends, it is for the first time in its history that the UTCS has undertaken such an initiative, that is having the 3 stakeholders, the police, the prosecutors, and the judiciary, in this conference hall to discuss and debate on the challenges in the implementation of new 3 criminal laws. Therefore, with the coming into force of the new criminal laws from 1st July 24, and as on today, 31st August 2024, we have completed 2 months of its enforcement. A need was thus felt that we must discuss the pain points, let me underline, the pain points in the implementation of these 3 new acts. The second objective of today's training program, ladies and gentlemen, is after the pain points have been identified, how to go about addressing them. I can understand the challenge of having this in one day, but of course we can take it forward. This is the broad backdrop of today's one-day training program, split into 4 sessions. In these 4 sessions, we have amongst us eminent jurists, distinguished lawyers, police officers, and civil servants. The valedictory session shall be addressed by the learned Attorney General for India, Mr. R. Venkatramani. I remember the great jurist V.R. Krishna Iyer once again, whom I had the privilege and honor of meeting him way back in March 1999 as a student of law. And I remember his famous words, I quote, criminal jurisprudence is an instrument of justice that must be tempered with mercy and understanding, unquote. This assumes even more significance considering how an element of victims' rights have been recognized in the new BNSS. With these words, I welcome each one of you. Welcome justices, our Honorable Chief Secretary, Additional Chief Secretary, Professor Vajpayee, all our prosecutors, police officers, IAS and DANIS officers, and all others who are present in this august gathering. Thank you, ladies and gentlemen.
Thank you, sir. It's a great honor to introduce Honorable Mr. Justice Rituraj Awasthi. Sir was elevated as a High Court judge in 2009, served as the Chief Justice of Karnataka High Court, and later as Chairperson of 22nd Law Commission of India. During his long tenure, he decided approximately 44,000 cases, including landmark judgments of national and international significance. He was also associated with the enactment of the new laws. Recognized for his contribution to law and public service, he received multiple awards and now serves as a judicial member of Lokpal of India. So please welcome Honorable Mr. Justice Rituraj Awasthi sir to the podium.
Thank you very much. Justice Manoj Ori, High Court Judge in Delhi High Court, Mr. Naresh Kumar, Chief Secretary, Government of Delhi, Professor Dr. G.S. Vajpayee, Vice Chancellor, NLU Delhi, Mrs. Chaya Sharma, Special Commissioner of Police Training, Delhi, distinguished guests, judicial officers, prosecutors, police officers, administrative service officers, ladies and gentlemen. Good morning to all of you. Before we consider the challenges in implementation of new criminal laws, we should first know what are the changes which have been brought in the new criminal laws. So, my endeavor would be to first highlight the changes which have been introduced in the new criminal laws and then discuss about the implementation, the challenges in implementation of those laws. Professor Vajpayee is here. He was associated in drafting of these laws, and I was also associated at a later stage, point of time. So it is just a coincidence that you would be also hearing Professor Vajpayee, who is a better person to highlight on the topic of the today. Over the last 10 years, India's legal landscape has undergone significant transformation, especially within the realm of criminal justice. It is a privilege to address this esteemed audience today to discuss the profound transition towards a more contemporary, victim-focused and effective legal system marked by the introduction of the Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita and Bharatiya Saksh Adhiniyam. The existing legal framework, largely inherited from British colonial rule, was originally designed to control rather than to deliver justice to the Indian populace. Many of these outdated provisions no longer alien to the needs of a society. The development of these new laws was driven by a convergence of socio-political factors, the demand for justice system that prioritizes victims, the need for legal frameworks that addresses technological advancements, and changing societal values were all crucial influences. Additionally, judicial activism highlighted systematic inefficiencies and international commitments also played a significant role in shaping these laws. Today's topic is very difficult. It will take a long time to understand and explain, but my efforts would be to be as much as brief as possible So please bear with me if my explanation is longer and it takes more time. I will try to be within the time slot which has been given to me. So as you are aware, the Bharati Nyaya Samhita, that is BNS, has been designed to replace the long-standing Indian Penal Code of 1860, that is BNS, which now comprises 358 sections, has made modifications to 175 sections, introduces 8 new sections and repeals 22 sections. It largely preserves the IPC provisions while acknowledging new offences, removing court-invalidated offences and increasing penalties for certain crimes. I shall quickly highlight some of the major changes that have been introduced. The BNS adopts a discerning approach towards combating contemporary challenges such as terrorism and organized crime. A notable feature of this legislation is the incorporation of community service as a punitive measure, underscoring a rehabilitative stance in the administration of justice. Among its key provisions, the BNS retains established offences such as murder, assault, and causing hurt, while introducing novel categories like organized crime, terrorism, and group-related grievous harm or murder. Terrorism is defined within the law as acts threatening national integrity or instilling terror, carrying punishments ranging from death penalty to life imprisonment. Similarly, organized crime encompassing offences like kidnapping, extortion, contract killing, land grabbing, financial scams, and cybercrimes incur severe punishments, including life imprisonment or death, along with financial penalties. It also addresses the issue of mob lynching, recognizing acts of murder or grievous hurt by 5 or more people on specified grounds as punishable offence carrying punishment of life imprisonment or death penalty. Moreover, it tackles sexual offences against women by prescribing life imprisonment as the minimum punishment for gang rape where the age of victim is under 18 years. It was earlier 16 years under IPC. And criminalizing sexual intercourse with a woman by deceitful means or making false promises. While it abolishes the offence of sedition or new offence for act endangering the sovereignty, unity and integrity of India has been introduced. Further, the recent statutory revisions encompasses the inclusion of snatching as a punishable offence under section 304 of BNS. The legislation also addresses death by negligence, elevating the punishment of such offences while specifying lower penalties for medical professionals. Finally, in alignment with Supreme Court decisions, it has introduced life imprisonment along with death penalty for certain murder convictions, demonstrating its commitment to contemporary legal standards and evolving societal norms. Friends, the Bharati Nagrik Suraksha Sanhita, that is BNSS, has replaced the Code of Criminal Procedure 1973, removing 9 sections from the current Act, proposing modifications in 160 sections and adding 9 new provisions. By instituting timeline for completing various stages of criminal trial, it seeks to improve accessibility and responsiveness to the people's legal needs. Some of the timelines fixed for investigation and trial requires committal proceedings to be concluded within 90 days from the date of taking cognizance, with the possibility of extension of up to 180 days. Supply of police reports and documents must be accomplished within 40 days from the production or appearance of the accused. Framing of charges in trials before a court of session should be completed within 60 days from the initial hearing on charges, and delivery of judgments in trials before a court of session within 30 days from the completion of arguments, with a permissible extension of 45 days. Section 173 of BNSS embraces technological advancements by permitting digital methods for trial, inquiries, and proceedings, thereby streamlining legal processes. A groundbreaking provision with the law is the introduction of zero FIR, as stipulated in Section 173, granting individuals the right to file a first information report at any police station for a cognizable offense, regardless of jurisdiction. Furthermore, it has mandated the swift transfer of such FIRs to the relevant police station for investigation within 15 days. It has also introduced preliminary inquiry prior to registration of FIR, which is limited to cognizable offences punishable with imprisonment of 3 years or more but less than 7 years. The same is to be carried out in a time-bound manner, that is 14 days from the receipt of information. The implementation of the crime and criminal tracking system is anticipated to provide substantial benefits to the public. In cases where a proclaimed offender is tried by absconding, Section 356 of BNSS allows for the trial to be conducted even in his absence. Section 107 gives the magistrate power to attach property identified as proceeds of crime. Moreover, the BNSS revises detention conditions for under trials, imposing strict criteria for release of personal bonds, particularly for those implicated in grave offences such as cases warranting life imprisonment or facing multiple charges. The legislation has also broadened the scope of medical examinations, granting a police officer of any rank the authority to request for the same, thereby enhancing accessibility to this essential procedure. Furthermore, forensic investigation for crimes carrying sentences of at least 7 years imprisonment has been mandated, while also stipulating electronic documentation of evidence collection at crime scenes. The law further extends power for sample collection, permitting the retrieval of finger impressions and voice samples from individuals not under arrest. Lastly, the legislation streamlines court hierarchy by eliminating the role of metropolitan magistrates in cities with populations exceeding 1 million, thereby fostering a more uniform judicial structure across the nation. Ladies and gentlemen, the Bharatiya Sakshi Adhiniyam, that is BSA, has substituted the Indian Evidence Act of 1872. It incorporates significant changes such as amendment to 223 sections, the addition of 1 new section, and removal of 5 sections. This act aims to establish updated rules and principles of evidence to ensure fair trials, taking into account technological progress and societal transformations in recent years, while retaining core provisions from the existing law concerning confessions, relevancy of facts, and burden of proof. The new law has introduced substantial modifications aimed at modernizing evidentiary procedures. It explicitly acknowledges electronic evidence. Moreover, the distinction between primary and secondary evidence is maintained, with primary evidence now encompassing original documents, electronic records, and also video recordings, while oral and written submissions are relegated to secondary evidence status. This ensures equivalent legal standing of electronic records as paper records, encompassing information stored in semiconductor memory, smartphones, laptops, emails, server logs, locational evidence, and voicemails. Section 57 of Bharatiya Sakshi Adhiniyam underscores the paramountcy of electronic records as primary evidence, while additional provisions within the Act facilitate the electronic presentation of oral evidence. This progressive step enables witnesses to testify remotely, ensuring that digital records carry equal weight to traditional paper documents. Furthermore, Section 24 of the Act expands upon the concept of joint trials. An amended explanation to joint trials now includes cases where one accused is absent or has not responded to an arrest warrant, thus expanding the scope of joint trial categorization. In the journey from old to the new criminal laws in India, a profound transformation is evident across various critical dimensions. It symbolizes a fundamental change in ideology and approach to justice. It demonstrates a dedication to safeguarding the rights of all involved parties, particularly the victims. However, as is the case with any wide-scale reform, the implementation of these laws is faced with its own formidable challenges. Successfully implementing the new laws will require significant investment in infrastructure, technology, and training, ensuring consistent application across India's diverse and often resource-limited jurisdictions will be a major challenge. The focus on technology could widen the digital divide, particularly disadvantaging marginalized and rural communities. The judiciary's ability to adopt to the new laws and procedures is vital, necessitating the training of judges and legal professionals to effectively understand and apply the new provisions. The increased reliance on digital evidence and technology in law enforcement also raises concerns about data privacy and potential misuse of personal information. It requires comprehensive change management strategies to overcome these hurdles. The effectiveness of these reforms hinges on its meticulous execution, well-defined directives, and ongoing oversight to ensure that the legislation achieves its intended goals without unforeseen repercussions. Friends, I wish to conclude by saying that though the path forward may be challenging, the proposed reforms offer the potential to create a more equitable, efficient, and responsive criminal justice system in India by updating the outdated colonial era laws with the modern and forward-thinking legislation